Good evening. This is John Milburn for Laws 12067. This is environmental law. We're into week 4 of term 3, 2019. And this week we deal with, if you like, the big picture items. We're dealing with international environmental law and federal governments. Now, these are huge areas, but of course we learned in week 1 that when we consider environmental law, we need to initially consider it from the perspective of international law. Very relevant for those of you that are keeping up with the news now in terms of the way in which Australia is interacting with some of its local neighbours in the South Pacific area. So when it comes to international environmental laws, we need to consider some of the main conferences, meetings that have taken place and some of the things that have come about as a result of that. At a federal level, the primary legislation is the Environment Protection and Biodiversity Conservation Act, the EPBCA. And from that, we then look further down at state powers, local powers, etc. But tonight we're looking at the larger umbrella. And it's from the international law that many of the principles that we talk about regularly in environmental law were derived. So, for example, the concept of ecologically sustainable development, which is now encompassed widely in domestic law, is something that began as a principle of international law. Now, when we talk about international law in this context, I'm really talking about public international law. I'm taking contract this year, contract B, and towards the end of the unit, we'll be talking about international law in that context as well. But overwhelmingly, that will be private international law, the law that relates to, for example, consumers in Australia interacting with Google in the United States. So that's private international law. When we talk about international law in environmental law, we're really talking about public international law. In other words, the law that regulates legal matters between states. And when I talk about states in international law, I'm not talking about Queensland, New South Wales, Victoria. I am, of course, considering countries. So rather than say countries, we tend to talk about international states in environmental law. It's, in short, environmental law at an international level is not particularly effective. It's much better than it was, and it's improving all the time, but it's not something that should be compared with domestic law in terms of its clarity and its enforceability. It's just not like that. International law and the international institutions that operate around the legal framework, they tend to be more cooperative in nature and rely much more heavily on collaboration between members of the international community. So if you're the government of an island nation in the Pacific complaining about the effects of climate change from the much larger nearby first world countries, then other than complain about it and bring it into the public forum, there's not much that you can do about it. And of course, we're seeing that this week. So enforcement of international law is not particularly strong. We'll talk about what can be done, but first of all, we need to consider how it comes into effect and what it actually comprises. It comprises mostly of declarations and treaties and commitments. And of course, international states are generally free as they see fit to come and go. So if an international state does not believe that it should be part of the particular accord, then it simply says we're no longer regard ourselves as bound by that. And there's not much that people can do about it. So it is improving, but it's still a work in progress. I guess a difference between that which we see in international law and that which we see in domestic law relates to the basis upon which the international laws are created. there's less, I think, and this is a bit of commentary, I think there's less that's political and more that is scientific, relatively speaking. However, environmental law at an international level still reflects scientific concerns, political concerns, and economic concerns and economic realities. Now, I'll give you a very good example of this. I mentioned one of the leading principles of international law is ecological sustainable development, or ecologically sustainable development. If we consider the international definition and indeed how that concept has filtered down into our domestic law, we'll see that it relates to an integration of human considerations such as economic development, maintenance of cultural, economic, physical and social well-being of people, and melding that with environmental issues. It is a mistake to look at environmental law purely from a scientific and environmental focused basis, because it is the environmental law molds together that which relates to the human aspects, economics, culture, development, and social well-being of people, and it blends that in with issues to do with, for want of a better term, protection of the environment. So keep that in mind when you're answering an environmental law question. People criticise me for making those comments because they say, well, surely environmental law is all about protecting the environment, but it's just not. That's potentially a political issue, but we're here, of course, to consider and apply the law. So in Queensland, we incorporate legislation that deals with ecologically sustainable development principles, and the Queensland legislation, for example, provides a system of achieving ecologically sustainable development by creating planning policies, regional plans, planning schemes, etc. So if you have a question that relates to issues around state levels, planning levels, regional plans, policies, etc., always look at answering a question that relates to that, at least to some degree, by reference to some of the international principles, such as ecologically sustainable development. All right, quick quiz to get you working. I know it's only a small group, so I'm not here to pick on people, but just to keep you on the move, can anyone identify some of the key or conferences that have led to the development of environmental law? Bearing in mind that this is really a new topic, environmental law. It's not like contract or torts or constitutional that have been around for a long time. It's a new branch of the law. Any international conferences, for example, that come to mind that are particularly relevant?
Are these the ones that we, sorry, am I echoing?
No, it's fine, Carolyn. No. We can hear you clearly.
Awesome. Are these the ones in our lecture notes, like the convention on biology?
Yes, there's two that I'm particularly thinking about. One was in 1972, the other was in 1992 to kick us off. Yeah, that's it, Stockholm and then Rio. So Emma says the UN framework on climate change. So I think a good point to start is the UN conference on human environment, which was held in Stockholm in 1972. Then in 1992, we had the UN conference on the environment and development. And just to give you an idea of the sort of things that were created as a result of these conferences, let's have a look at the Rio Declaration on Environment and Development from 1992. So that document came about as a result of the meeting from the 3rd to the 14th of June 1992. And it's a declaration, and it's a proclamation of those states that became signatories to it. And whilst the principles can be laudable in their nature, we come back to that key issue that relates to the enforceability. And you'll see that whilst these principles are very important, they're in some ways aspirational in that they're not supported by the usual things that we see in legislation, such as remedies for breach or penalties or enforcement proceedings. They're really statements of principle. But in answering an environmental law question, I think it's useful to go back to some of these originating documents because it partly explains the legislation, but it also provides you with an argument that you can use in presenting a case. So if you want some support for a proposition, then looking at these general principles is always a good idea. And we'll talk about Tio's case shortly, which deals with the way in which you can use these principles in answering an environmental law question. So in 1992, the UN had this conference on the environment and development at Rio de Janeiro. We had the Charter of Rio conference to create strategies, and the aim was to create these strategies and measures to halt and reverse the effects of environmental degradation. It relied on national and international levels, and states had an opportunity to become signatories. Now, just a quick yes or no. If, for example, Australia becomes a signatory to a treaty, does it then become part of our Australian law? Yes or no?
Not immediately.
Yep, so Emma was really quick to say no. Carolyn says no, not immediate. Kathleen says need to be ratified. Emma says needs to be written into our legislation. Absolutely, and Thomas agrees as well. So that's the correct answer. It has a persuasive effect, but it's not strictly part of our law until it's built into our legislation domestically. So the Stockholm Declaration, the Rio Declaration were otherwise described as the first and second global environmental conferences, and these were what kick-started much of the principles that we talk about. So the focal point was regarding the environment, of course, and the rules that relate to the way in which states deal with each other. Can anyone tell me where states might take a grievance if they wish to take action against another state? I've said enforcement is not particularly strong, but I didn't say it's non-existent. There are some opportunities. Any thoughts? Any thoughts on where you can take the grievances? International Court, says Kathleen. Karen says the International Court of Justice at The Hague. Yes, very good. All right, so let's have a look at the International Court of Justice. I'll share the screen. Has anyone been fortunate enough to actually go there? I was there a couple of years ago, actually, at this time. While I was teaching environmental law, I was at the International Court of Justice. I wasn't working, I was a tourist looking at it. So you can see there, it's a beautiful building, great to go and have a look. And of course, it provides a lot of useful information. So if you're looking for a good resource for international law at that international level, I'd recommend this website, International Court of Justice, which provides some very good background. Now, essentially, international law comprises of four sources: treaties, international custom, general principles of law, and then subsidiary sources, such as decisions of courts and tribunals, and the writing of jurists. So if we equate that, if we cross-reference that to our sources of law at a domestic level, we talk about primary and secondary, don't we? We talk about primary sources of law being statutes and common law, case law, and secondary sources of law being texts and other materials that are essentially commentaries. So it's quite different. International law Number 1, treaties. Number 2, international custom. Number 3, general principles of law. And then number 4, way down at number 4, subsidiary sources such as decisions of courts and tribunals, and then academic writings. So treaties are the starting point. They're probably the most important, but confusingly, they're not always just called treaties. They are sometimes called conventions or agreements or protocols. And they're different to international custom because there's a commitment in writing is the key issue there. So treaties are signed more readily by those member states that don't have an economic interest in the content. It's easy, isn't it, to be a signatory if it's not going to affect your back pocket. And that's usually the sticking point. But as we identified, signatory alone is not binding. It can be useful, but it's not binding. Now, customary law is the second source, and it's what we really refer to the internationally accepted practice on a certain matter. So that can be to some degree binding. The third is general principles of law, such as good faith. For examples of general principles of law, have a look at Article 21 of the Stockholm Declaration, or Principle 2 that we had on the screen a moment ago of the Rio Declaration. And they're general principles saying states must not cause environmental damage to neighbouring states. So if you're an island state in the Pacific and you wish to complain about what Australia is doing, then you'd probably refer to Principle 2 of the Rio Declaration as your opening statement to support your arguments. Now, of course, subsidiary sources are tribunal decisions, court decisions, and go to the International Court of Justice website for that. So, can anyone tell me how we enforce international laws between member states? We have the International Court of Justice, but are there any other general ways that we seek to enforce environmental laws? Any thoughts? In this sense, it's not too much different to what you might do domestically. Probably a good starting point: negotiations, alternative dispute resolution, mediation, conciliation. So, but the problem is that states themselves generally have the role of enforcing the international laws. Now, states may agree to submit to arbitration, and the Court of International Arbitration is also in The Hague. Member states might be able to present cases and present their arguments in good faith. The International Court of Justice is the principal judicial arm of the United Nations, but again, compliance is difficult. Now, I mentioned earlier the problem that international law isn't directly enforced in Australia until the domestic law is passed. The authority for that is Minister for Immigration and Ethnic Affairs against TEOH. It's an important case to have, obviously, for a number of reasons. The citation is 1995, 183 CLR 273. And when it comes to dealing with international law, apart from the International Court of Justice, another very good website is the High Court website. We'll just share that now. And the High Court of Australia website provides information about recent decisions. It also provides good commentaries, and you can subscribe to judgment alerts. So particularly in this term, if you're interested in international environmental law, then it might be worthwhile subscribing to get up-to-date information as it comes out. And the summaries in the High Court page are very useful. It's a resource that's probably underutilised, but in environmental law, particularly useful. All right, well, I mentioned that when it comes to environmental law, we really have these general principles. Now, I've mentioned a few times already the importance of the precautionary principle. And does anyone want to tell me what we mean by the precautionary principle? Anyone keen to explain it? It's one that's...
Have a go.
Thank you, Kathleen.
So it's where you make decisions based on what might happen rather than waiting for it to happen and then fixing it afterwards.
Yep, that's a very good start. So the precautionary principle is the opposite of wait and see. It's let's get in and do something now before it's too late is a good way of looking at it. Yes, that's another good way of looking at it as well, Carola. That's excellent. What type of evidence do you think we're talking about when we're considering the potential environmental damage that might be caused? Kathleen's onto it, scientific. All right. In civil law, we talk about the balance of probabilities, which is 50-50. We talk about how that might be amended as a result of applying the Briginshaw test, still 50-50, but we need better proof. Beyond reasonable doubt means, well, beyond reasonable doubt, we don't say percentages. But when it comes to scientific certainty, has anyone come across the generally accepted figure for what represents scientific certainty? It's usually 95%. So if there are threats, so this is where the precautionary principle reminds me a little bit of Briginshaw. You know, the Briginshaw test where you need to be satisfied to you need to have good evidence. And the more serious the matter, generally speaking, the more cogent the evidence needs to be satisfied, even though you still need to be satisfied on a 50% basis. So with the precautionary principle, we're really considering threats of serious or irreversible environmental damage. We're not really talking about actual environmental damage. We're talking about the threat, and it needs to be serious. Now, if we have those two magic phrases, the threat of serious or irreversible environmental damage, number one, serious, number two, damage, then the lack of full scientific certainty beyond 95% should not be used as the reason for postponing measures to prevent the environmental degradation. If the threat is serious enough, then we don't wait for full scientific certainty before we act. If the threat is serious enough, we don't wait for it to happen before we take action. That's essentially what we mean by the precautionary principle. And you can see that it's a very powerful argument that you use in certain circumstances, particularly if you're involved in prosecution of matters.
Can I just ask?
Yes, Carolyn.
So if we wait, say, 5 years because of the who determines the level of success?
Yes, that's a really good question. So who determines this? It's all very well to say the lack of full scientific certainty should not be used as the reason. The answer is it's evidence-based and it's scientific-based. So it needs to be experts in the field who provide some evidence in relation to a matter. And this is where it's difficult because the experts may not agree, and the people that interpret that which the experts are saying may not be consistent in the way they go about interpreting that material as well. Couple that with the fact that we don't necessarily have a forum where this is properly argued. Yeah, sorry, Karen.
Wasn't that part with the paradise? Because on one side, the scientists are all saying Well, there's been lots of spawning and it's not good, but in actual fact, what's come out since then, they might but they're not actually. Because something was written the other night, that video said that they've actually had two juvenile that have been.
Yes. Unfortunately, the audio for me was cutting in and out. It was a little bit like that with you, Carolyn, as well.
Yeah.
Were others struggling to hear everything that Karen said? It's echoing by the sound of it. Sorry, Karen. I did pick up most of it. And you're right, the precautionary principle is an important matter in that as well. Emma, are you all able to hear me clearly? All right. It might be something to do with me keeping my microphone on. So when others speak, I'll turn my microphone off. That might be the magic solution. Sorry, Karen. Did you want to raise that issue again and we'll just try the audio? No? Okay. Thank you. But we get your point. I think it's a very good point. So the precautionary principle is one that requires decision makers to consider when coming up with solutions or responses to various proposals. Another matter is intergenerational equity, which is highly relevant. Those of us that are more senior in years have less to lose, don't we, than those that are young now, inheriting the world that we leave behind. And there's got to be some equity between the generations. We don't think about that in domestic law, but it is a principle of international environmental law. And essentially it means this, that the present generation should ensure the health, diversity and productivity of the environment is maintained or enhanced for the benefit of future generations. It's a general principle, like the precautionary principle. Okay. Now, I mentioned that in a way, a lot of this filters down. We have the international level at the top, providing the general principles, and then I've mentioned the role of the federal government in implementing environmental laws. Can anyone remind me of the fundamental problem that we have when we're talking about the government creating environmental laws and trying to actually implement into legislation some of these things that they've committed to by signing treaties? What's the fundamental problem? I've turned off my mic, so if you speak it, hopefully it will be better. But Karen's onto it. If it's not in the Constitution, the states won't necessarily accept it and may challenge it. So the 80s was a good time for constitutional lawyers in Australia because we had many cases where states were taking on the Commonwealth in the High Court, arguing that legislation was invalid, and pretty much the states lost on every occasion. That led in the late 80s, early 90s to COAG. But from an environmental law perspective, the key case, the Tasmanian Dam case, was Commonwealth against Tasmania, 1983, 158 CLR 1. So the federal government was able to establish in that case that it could use other powers to avoid the problem of not having direct constitutional power to make law in relation to the environment. And I mentioned that eventually the spate of constitutional cases slowed down, and it led to the intergovernmental agreement on the environment, 1992. And rather than litigate in the High Court, the states and the governments and the federal government adopted this intergovernmental agreement on the environment as a way of cooperatively acting on environmental issues rather than fighting about who had the power to make what laws. In some ways, it was the states conceding to the government, the federal government, the ability to make laws in relation to certain things. So some of the key aspects of the Intergovernmental Agreement on the Environment are found in the preamble to the document, which talks about the benefits of having a cooperative national approach to the environment, a better definition of the role of respective governments, a reduction in the number of disputes between the Commonwealths and the states, greater certainty of government and business decision-making, and ultimately better environment protection. So the document allowed for a workable model to allow for the efficient and effective administration and political processes to enable environmental policy to actually be implemented. But before the Tasmanian dam case, there was another very important case. It related to issues on Fraser Island, as I recall. That's Murphy Oars Inc., Pty Ltd, against the Commonwealth. 1976, 136 CLR 1. And that case was the original High Court case that determined that if a law fell within the subject matter of the Commonwealth decision-making power, the law will be valid even if it relates directly to environmental matters where the Commonwealth did not have the constitutional power. So if you're answering a question that relates to the way in which the Commonwealth might implement and make into domestic law some of these international commitments that they make through treaties, then probably a good starting point is Murphy Oars, in conjunction with talking about the Constitution and some of the powers that are conferred upon the Commonwealth under the Constitution that they use as piggybacks to enable environmental law to be passed. So the key ones there are Section 51. Of course, we're talking about Section 51 of the Constitution. 51.1 gives the Commonwealth power to make laws in relation to trade and commerce. So that's a useful one to rely upon for the Commonwealth to make environmental laws. Others, subsection 2, financial powers. Subsection 10, fisheries. 20, corporations. 29, external affairs. And 31, power to acquire. Now, Section 51, subsection 31, which is XXXI, as it's written, so Roman numerals, is that section that talks about acquiring property on just terms, which compels the Commonwealth government to compensate for the compulsory acquisition of property from any state or person but to do so on just terms. And of course, that's what was the key to the castle, wasn't it? So have a look at what it means to be property. We talked about this earlier. Have a look at the case of mutual pools against the Commonwealth, which is 1994 CLR 155. And there must be the acquisition of at least some identifiable benefit or advantage. In other words, merely depriving someone or modifying or restricting is insufficient. There needs to be some benefit or advantage to the Commonwealth in order for it to potentially be an acquisition of property. So when it comes to looking at Section 51, subsection 31 of the Constitution, I guess another way of looking at it is that we have a constitutional guarantee that if the Commonwealth government seeks to deprive you of property, then you are entitled to compensation on just terms. Now, of course, we don't have that in the state jurisdiction. There's no counterpart for the state laws, which potentially makes it unfair depending on who it is that is purporting to take your property. Other important constitutional matters, Section 90, which deals with customs and duties, something you should probably consider if you're answering a question on this topic. And also Section 92, which means the Commonwealth has power to make laws in relation to Commonwealth places. And Section 52 of the Constitution confers on the Commonwealth exclusive power to make laws for peace, order and good government in relation to government places. And Section 109 is just a general provision that you should always consider when you're dealing with constitutional matters, and it provides that to the extent of any inconsistency between federal and state legislation, then Commonwealth prevails. All good? I know that was a fly through. Yes, Karen?
Just a question. I came across it somewhere in my reading. I can't remember where. With regard to the acquisition power, what if it's a Commonwealth funded state project, something like, say that the Pacific Highway or the Bruce Highway, and they're widening the road and they want your property? Because it's a state thing, can you get some sort of just compensation by saying, well, it's actually being funded by the Commonwealth?
And the answer, that's a really good point. And the answer is yes, you can. What usually happens in practice is that the states decide that if the Commonwealth wants them to act in a certain way by making resumptions or providing some degree of restrictions even, then the states will ask the Commonwealth to either fund it or at least contribute in a substantial way. So an example of that that comes to my mind was some years ago, the Queensland government wanted to introduce tree clearing laws that restricted the ability to clear, and landowners were complaining that that affected their livelihood. So even though arguably it wasn't an acquisition, which therefore even at a Commonwealth level wouldn't necessarily trigger the just terms compensation, through cooperative arrangements, funding was made available by the Commonwealth to the states, and payments were then made to those people that were adversely affected. But it's not constitutional, it's more a negotiation, and quite often it's political, but it's still there, it still operates. So good point, Karen, thank you. All right. Now, of course, we mentioned that the key piece of legislation for the Commonwealth is the Environment Protection and Biodiversity Conservation Act, 1999. I just want to highlight a few key points because this does relate to how the Act operates in practice. I'd start by looking at sections 3 and 3A. Section 3 provides the objects of the Act to protect the environment, to promote ecologically sustainable development through conservation and ecologically sustainable use of natural resources. So if we stop there, we'll remember back to what we said at the start, that when we talk about promoting ecologically sustainable development, we're talking about not just protecting the environment, but we're talking about all those other things as well, economic, cultural, and other aspects. Other objects of the EPBCA: to promote conservation of biodiversity, to provide for the protection and conservation of heritage, to promote a cooperative approach to the protection and management of environment involving governments, community, landholders, and Indigenous people. So that might come back to your point, Karen, about the way in which the Commonwealth is obliged under its own legislation to promote this cooperative approach to matters. Also, the Act requires, or an object is to assist in cooperation of implementation of Australia's international environmental responsibilities. So there we see the introduction of an obligation for the Australian Parliament to attempt or the Australian executive to attempt to implement international environmental responsibilities. So if you're answering a question that is to some degree based on seeking redress or enforcement through the Commonwealth level, and you're relying upon, for example, one of the preambles or principles in the Rio Convention, then you might refer to the Section 3 objects, which require the government to implement its international obligations in that regard. The next section is 3A, which deals with the principles of ecologically sustainable development. So there we have that phrase again. And again, just don't gloss over that, but think about what that phrase, what that principle actually means when we talk about it from an international perspective. And you'll see here that there is a list of the principles that are principles of ecologically sustainable development. And this incorporates a few of the things that we've already talked about. So decision-making processes should effectively integrate long-term and short-term economic, environmental, social, and equitable considerations. So we see there that even though this is the Environment Protection and Biodiversity Conservation Act, one of the key principles of ESD is to consider economic as well as environmental and social and equitable considerations. The other thing that stands out to my mind from that is that there's talk of long-term and short-term, and that begs the question of intergenerational equity, doesn't it? Which is referred to a little later. The next principle of ecologically sustainable development is, well, this looks a bit like the precautionary principle, doesn't it? If there are threats of serious or irreversible environmental damage, lack of full scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. So that is the precautionary principle. So we can see that under the EPBCA, the precautionary principle is in fact a subset of ecologically sustainable development. We talked about international generational equity. That's also a subset of ecologically sustainable development because it's listed as one of the principles in section 3A of the EPBCA. And then it goes on to talk about the conservation of biological diversity and improved valuation, pricing and incentive mechanisms are to be promoted. Another important aspect of the EPBCA is that it does concentrate on matters of national environmental significance. So if you see that phrase, NMES, national, MNES, matters of national environmental significance, then you'll see that it refers to World Heritage Properties, National Heritage Places, Ramsar wetlands, and the Ramsar Convention is a convention on wetlands of international importance. Matters of national environmental significance also include threatened species, nuclear action, Commonwealth Marine Parks, Great Barrier Park, Reef Marine Park, and water resources from coal seam gas development. The next section I'd ask you to look at is 523 of the EPBCA, which defines certain actions which have the effect of triggering processes under the Act. So certain types of action, the emphasis on the word action there, trigger processes under the Act. Have a look at section 523, which defines an action. An action is a project, a development, an undertaking, an activity or series of activities, or an alteration of any of those. So it's really very broad. So if you're answering a question, you need to ask yourself, are the processes under the EPBCA triggered in a particular circumstance? starting point, consider section 523. Is this an action that is defined? Now, I know I'm jumping around the Act a bit, but when we talk about actions, one of the key ones is a controlled action. And you'll probably come across this later in the unit. Have a look at section 66 of the Act, which provides for a simplified outline. Look, I'm just going to share the screen here, and thank you for your patience. You're doing really well, but hang in there. Let me see if I can find this correct screen. You should now see an extract from the Federal Register of Legislation, the EPBCA, section 66, which provides for a simplified outline. That's a useful starting point. From there, we pan down, and section 67 refers to what is a controlled action. And that's important because there are certain things that would be otherwise prohibited. Then go to sections 74 and following, which provide for, sorry to pan so quickly, referral proposals. So when there is a referral proposal, section 74 provides the Commonwealth Minister an opportunity to invite other ministers and other states and territories to provide information. So the referrals process that we're talking about here is a situation that occurs when a proponent of an action, and we know that action is very broad, believes that a controlled action may be triggered, and therefore this referrals process needs to be considered. So I think the best thing I can do is ask you to look at these sections, just study them and take them in. So the ones I've referred to, you'll need to consider also section 74, which is on the screen now, section 75, and have a look at the definition of the term impact, because they talk about this having an impact. So the impact is defined in section 527E. And the Commonwealth actually has some published guidelines in relation to some of these things, how to determine significant impacts. So the Guide to Strategic Undertaking is there and worth having a look at. So this is the Australian Government Department of Environment and Energy, a guide to undertaking strategic assessments, and you'll see the PDF and Word version. And you'll see that the purpose of the guide is to explain the strategic assessment process of the Australian Government's National Environmental Law, the EPBCA. Now, the reason I'm showing you this is it's one thing to talk about the protection of the environment consistent with general principles, but the next question is, well, how does the executive go about undertaking assessment? How does it deal with matters that are determined as being controlled actions, matters that are considered as having international and national significance? So these published guidelines do assist in that regard. And it will help you to determine whether something is a matter that requires consideration as to whether it's a matter of national environmental significance or not. So try to understand the referrals process, have an understanding of what we mean by significant impact, have an understanding of what we mean by the strategic assessment. Now, when it comes to the minister deciding whether a proposed action is controlled, the minister must apply the correct test. So what I mean by that is that whilst when you look at this material, you might think, well, the minister has almost unfettered power to make decisions. That's not entirely correct. So, for example, if we look at the Nathan Dam case. And here we have the project overview from a Queensland state government perspective of the Nathan Dam project. The minister determined that the dam did not pose a threat of significant impact on the Great Barrier Reef. It was meant to be built, it was proposed to be built several hundred kilometres upstream. But the minister considered the matter and said that the impact was low, but it went to a court who determined that the minister adopted the wrong test. So the point about that is that the ministerial discretion, albeit very wide, is not impossibly wide, and it's not impossible to challenge it. I mentioned earlier the International Governmental Agreement on the Environment, and that's important in that it provides for this bilateral agreement between a state and a Commonwealth as to accreditation of environmental assessment or actions. So when we look at the EPBCA, you'll see that there's reference to environmental impact assessment processes. And if you look at state government legislation, you'll see the same thing. And the idea of the International Governmental Agreement on the Environment is that the states and federal government have, to some degree, elected to be cooperative in the way that they make these assessments so that people aren't overly burdened by what might be described as red tape. So have a look at section 87 as well, which provides for different approaches that might be undertaken by the minister in making assessments. And I'm sorry again to be panning. I won't pan down any further. In fact, I'll stop the share. So it's probably best if you study that privately. So have a look at section 87 and then have a look at sections 130 and 134. 130 and 134 deal with the approvals process and provide some of the mechanisms by which the minister must decide whether to approve the taking of controlled action or not, and to determine, in amongst other things, economic and social matters and the consequences of action or inaction. Oh, that's been a lot of words. You've been very patient, you've been very good. So tonight, what we've attempted to achieve is an overview of the international law and specifically how it's filtered down into the Commonwealth level, how the Commonwealth had power constitutionally to do something about implementing the international obligations. We've also talked to some degree about the sort of arguments that you might make by relying upon international law and federal law if you wish to advance a particular argument in a case. All right. Any questions before we wrap up for this evening? All good? Now, next week we're not meeting. So next week is the break week. It's a chance to catch up, catch your breath. And then, so what that means is that in 2 weeks from tonight, Tuesday in 2 weeks, we'll be meeting again for the week 5 material. Okay. Thank you very much for your patience. Really pleased that you joined me this evening. Thanks for your good work and we'll see you next time. Okay. Bye then.